Thank you, Stefan. Good afternoon or almost good evening, colleagues. Thank you for all still being here. I've been told that there's some riveting speakers coming after me, so bear with us. I am Erik van der Vyver. I'm a South African qualified patent attorney, but I practice and advise largely in South Africa, but throughout the whole of Africa. For those not familiar with the place, even though it's got about the same number of people as India, Africa is actually not a country to the south of Europe. It's a collection of almost 53 countries. So to explain patent eligibility in a high-tech field such as computer implemented inventions or biotech in one country or one region like Europe can take almost 20 minutes. To explain them in all 53 countries is virtually impossible. So what I'm going to do is try and give you an overview of the South African systems, but also the repo system, with which I'm very familiar. Our offices, we have offices in South Africa and Namibia, which allows us to file directly into a repo as well. Okay, I just want to figure this out. Here we go. So, trends in Africa in terms of patent filings is very similar to trends throughout the rest of the world. There are certain technologies which are much more popular just because of the specific needs the people of the countries throughout Africa have. But looking at this, what's interesting is that computing and peripherals, which in my analysis also includes things like banking, mobile banking, securities, online, e-commerce, together with telecommunications and semiconductors, which is closely related, make up more than 50% of all the technology that is going on at the moment, which is, and that applies in Africa as well. Further interesting is that the medical device and pharmaceuticals make up about a further 15%, which, of course, there's a big market in Africa, and it's in a market that is developing very quickly. So those technologies tend to lead the way in terms of patent activity on the African continent. So what I'm going to look at is sort of the ITC inventions, patentability of CIIs, a little bit on biotechnology. I don't understand anything about those bugs, but I will try and tell you what the situation is in South Africa as well as in Arepo, and then also touch on pharmaceutical and medical technologies. So what you also need to understand on the African context is that most of the R&D and most of the new inventions coming out of Africa come almost, I would say, 95%, if not more, come from South Africa. It's merely because the rest of the African continent have unique challenges. They are not conducting lots of R&D yet, but that is changing very rapidly. So the rest of Africa, excluding South Africa, is almost exclusively importers of intellectual property and importers of new inventions and patents. Not a lot going out of it. South Africa has a fair amount of invention and R&D going on, which goes out to the rest of the world, and you will be familiar with some of the inventions that have come from South Africa. For example, a method of performing a heart transplant, which ironically is not patentable. Attack helicopters, nuclear reactors, things. South Africa has a very active, inventive industry. So the South African Patents Act, most of you will recognize. It is almost exactly the same as the UK Patents Act, but also the European Patents Act, purely because we inherited it from UK. In fact, when I say inherit, I use the term loosely. I think we just copied it. But it is it's also almost identical. So those things, well, patents can be granted for new and inventive things capable of being used in trade or industry or agriculture, and certain things are specified as not being inventions as such. And those things are almost the same as was explained earlier with regards to the European patent system. Further things that are excluded from patentability are inventions that are expected to encourage offensive or immoral behavior, any variety of animal or plant or essential biological process for their production, those are the animals or plants themselves, and methods of treatment of the human or animal body by surgery or therapy or of diagnosis practiced on the human body. And there's been some case law on that. If I take things out of the human body, then practice the methods on them and put them back into the human body, then that is patentable, but not on the human body. Touching first on computer-implemented inventions, and again you'll see a lot of similarities with the European situation and in particular the UK situation. Things that are not considered to be patent eligible is pure code. Abstract ideas captured in pure code. Techniques for sorting numbers more quickly is a classic example. Business methods with no technical character are expected not to be patent eligible. And on the flip side, things that are patent eligible are computer-implemented inventions that have a technical character. We are expected to follow the European decisions in most regards, and so we expect the technical solution to a technical problem approach to be followed. Although, as I'll mention again later, there's been no strict or firm case decisions on it. At this stage, we are operating in a bit of a void. We're doing things because we think they will be allowable, but we expect to follow the European situation quite carefully. As I mentioned, or as you may have known, there was mentioned in previous presentations, South Africa is a patent registration country, which means there's no substantive examination, which has a bit of an advantage if you want a granted patent at all costs. You can file anything in South Africa and you will get a granted patent. But the risk is unenforceability. So while you could file anything, if it falls within the excluded subject matter or the non-patent eligible subject matter, you will not be able to enforce those patents. Our courts have made very, very few decisions on the patentability of CIIs, but as I said, we expect it to follow the approach in Europe, of which you now have a very detailed knowledge. Technical effect requirements, as I mentioned. Despite all these things, and despite the fact that we haven't had many decisions, a large volume of CII-based patent applications are being filed, and as a matter of course being granted. An interesting phenomena that we're seeing more and more recently is that the local inventive R&D industry are opting to file first instance applications in countries that do have examination, most notably the US. Largely the reasons they put forward is that the investor, if they're looking for foreign investment, they tend to give a lot more weight to applications and examining jurisdictions, particularly jurisdictions that are more friendly to computer implemented inventions, which used to be the US pre-Alice, but as we heard yesterday, there are definitely ways around Alice. If you look at the rest of Africa, and again, this is not only a repo, there are 53 countries to consider. The rest of Africa, computer programs are not patent eligible in the majority of them. Those include all the OAPI countries, which I won't repeat, Algeria, Botswana, Djibouti, Ethiopia, Morocco, Mozambique, and Namibia. What is a bit more interesting, though, is that in certain countries, like Burundi, Rwanda, and Zanzibar, they do allow certain things which could, in other countries, be classically explained as pure computer programs. For example, processes and inventions consisting of steps performed by a computer and directed by a computer program. That is the only thing. They specifically says that those countries will allow those patents. Also, product inventions consisting of elements of a computer-implemented invention, including, in particular, machine-readable computer program code, general-purpose computers whose novelty over the prior art arises primarily due to its combination with a specific computer program. So I think the thing to take away with this, you can't explain the situation in every country, is that there are finer, small little nuances between all the countries in Africa. So, but because there's so many of them, if there are particular countries that you are interested in, the best is to seek advice on the specific country, on the specific issue. Because it may just be that you might find jurisdictions that are friendly to certain inventions, whereas the rest of the world might not be. Moving on to biotechnology, things that are not patent eligible, clearly animals and plant varieties themselves, it's not unique. Things that are patent eligible, and just to clarify, this is again the South African situation. Things that are patent eligible, however, are microbiological processes and products, including isolated and purified gene sequences, as well as natural substances derived from animals and plants. Something that is quite unique to Africa and other developing countries throughout the world is the concept of indigenous knowledge. Now, again, indigenous knowledge comes into play when local or resources or knowledge local to that country are being used in further inventive things, in further innovation. So where an idea or an invention originates from a country where such things aren't in place, it's highly unlikely that you are making use of indigenous resources. However, in the situations where you are, you need to be aware that there are certain implications. In South Africa, IK is know-how, skill and practice that are developed, sustained and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. It can patent an invention based on IK, and South African government has specifically implemented legislation to deal with this, and it requires the applicant to provide proof that it has received permission to make use of the indigenous resource or TK or traditional use. If R&D involves IK, you must notify the Department of Environmental Affairs, but most importantly, there must be material transfer agreements and benefit sharing agreements in place with the holders of the indigenous knowledge. Those are things, obviously, that your South African attorneys will guide you through. Moving to the pharma and medical sector in South Africa again, as I mentioned, methods of treatment of the human and animal body are considered not to be patent eligible. It does not apply to new substances for use in a method of treatment or diagnosis, but also new methods. Substances used in new methods are generally considered to be patentable. The whole question of first medical use and second medical use, it's clear that first new medical use is patentable. The view seems to be that even second and subsequent medical uses are patentable, provided, of course, the use is a new one. Swiss form claims, I presume most of you are familiar with Swiss form claims. They are still allowable under South African law. I know the situation changed recently in Europe. However, in South Africa, nothing has changed, so they are still available or allowable. Looking now at a repo, and there's been some good information on a repo given at this session. It's a fantastic system. It's operating well. It's run well. And it's working. So it's definitely something that you can advise your clients is worthwhile looking at. For those of you who don't know, a repo is a regional system which looks a little bit like the EPO system. It's a single application, single filing fee, but you designate countries, member countries, at the time of filing. From there is a central examination, which is at this stage operating relatively good. And they are responsive and things are going through at a reasonable pace. One thing that's slightly different to some other systems is that also your renewal is based on the per country basis. So if you've designated all 18 member countries of a repo, you can expect your renewals to be 18 times the normal fee. So which makes it quite an expensive system, but still, while you can file directly in most of those countries, it is oftentimes more cost-effective to file in a repo system designating only 1 or 2 member countries than it is to try and file applications directly into those countries, purely because the systems are not set up properly and just haven't got the resources to deal with them. Another important thing to note is that while a repo application is granted centrally, the enforceability or the validity of that patent still depends on the country in which you're trying to enforce it, which is, as I understand, not dissimilar to the European system. Some national laws on patentability of repo members are mostly the same as South African and European provisions for that matter, but with some noteworthy differences. Things that are not considered to be patent eligible, substances as found in nature, even if isolated or purified, and that only applies to Botswana, Namibia, and Rwanda. Admixtures of known substances for use as food or medicine in Malawi and Zambia. Biological process for the protection of plants and animals other than non-biological or microbiological processes. Again, it applies only in Ghana and Sierra Leone. And molecules or substances for the use and treatment of life-threatening diseases that the minister may designate. It applies to Kenya. Now, I have a Kenyan associate here. He was here earlier. I see he's probably already left. He promised not to ask difficult questions, and if I get anything wrong, he promised to just agree with me and argue it my way. So you can speak to him afterwards. Are there any particular questions on Kenya that you'd like to ask? Also things that are not eligible in Rwanda, pharmaceutical products for purposes of international conventions, to which Rwanda is a party. And in Uganda, minister may exclude certain products or processes of manufacture from being patentable for a maximum time of 2 years. Again, all this tells you is that there are certain quirks to various countries in Africa, so get the advice before you go there. Again, traditional knowledge applies in REPO member countries that are all parties to the Swakopmund Protocol on the protection of traditional knowledge and expression of folklore. I will not go through it in detail or repeat it. Bear in mind, when you're dealing with Africa, there's a possibility that you're also dealing with traditional knowledge. So, how are worldwide technology trends impacting on Africa? Because of the particular needs and requirements in Africa, you find that certain technologies are really flourishing in Africa. In particular, computing and peripherals.